Good afternoon and welcome to this afternoon's session of the Justice Select Committee on reform of the Family Court. I'm going to ask our first panel of witnesses to introduce themselves briefly, but first the members of the committee will make any declaration of interest they wish to make, starting with Lindsay Farnsworth.
Hello, my name's Lindsay Farnsworth. I'm the Member of Parliament for Amber Valley. Before being a Member of Parliament, I was a Crown Prosecutor for 21 years. My interests are declared in the Register.
Hello, good afternoon. I'm Warren Digges, Member of Parliament for Wolverhampton West. I'm a member of the GMB Union Executive Council, member of various APPGs. I'm a solicitor, although not practising at the moment.
Matt Bishop, Member of Parliament for the Forest of Dean. Previous career was police officer, and my other interests are as declared.
Afternoon, I'm Pam Cox. I'm the MP for Colchester. My interests are as declared on the Register. I would just add that I'm the chair of the APPG Penal Affairs.
Annie Slaughter, MP for Hammersmith Chiswick. I'm the chair of the committee. I'm a member of the GMB and Unite Trade Unions, a non-practicing barrister, and the patron of two justice-related charities, the Upper Room and Hampton Fulham Law Centre.
I'm Sarah Russell. Prior to my election, I was a solicitor specialising in employment law. Relevantly for this, for many years prior to me qualifying, I was a secretary in a family law department, on and off. I'm doing both private and public family proceedings, supporting them, obviously. I am a member of various trade unions, and my interests are per the Register.
Hello, my name's Tessa Munt. I'm the Member of Parliament for Wells and Mendip Hills. I'm not a solicitor or a barrister, but I have a particular interest in Whistleblowers UK, all of which is declared on the interest, and I'm the Vice Chair of the Penal Affairs APPG.
I'm Neil Shastri-Hurst. I'm the Member of Parliament for Solihull West and Shirley. I remain a registered barrister and an associate tenant in number 5 chambers, and my interests are as declared on the Register.
Hi there, my name's Tony Vaughan. I'm the MP for Folkestone and Hythe. I'm a barrister, associate tenant at Doughty Street Chambers, and I'm currently still hold a practicing certificate.
I'm Josh Babarindi, Member of Parliament for Eastbourne. I also am not a barrister or a solicitor, but I do have an A-level in criminal law. And my interests are as declared on the Register.
Good afternoon, my name's Anna Dixon. I'm MP for Shipley constituency. I'm a member of the Public Accounts Committee. I'm guesting today, given that the Public Accounts Committee recently considered the family courts. I've come to join this committee just for this session. And I guess the only possible relevant declaration is that my mum is a retired magistrate and was for many years a magistrate in the family courts.
Thank you very much. And could I just ask our witnesses very briefly just to introduce yourselves to the committee, starting with Jacky Tiotto.
Yes, Jacky Tiotto, thank you. Chief Executive at Cafcass since 2019.
I'm Nicole Jacobs. I'm the Domestic Abuse Commissioner for England and Wales.
And I'm Lisa Harker. I'm Director of the Nuffield Family Justice Observatory.
Thank you very much all for attending. I'll begin just with a couple of sort of framing questions. The family court has undergone reforms in recent years aimed at tackling delays and improving the experience for its users, some of which we'll be discussing today. Could you briefly set out how you think the family court is currently performing in this area? And I'm happy, you don't all have to answer each question. I'm happy to leave you to sort out who goes in which order.
I have a start at that. Thank you for the question. I think the family courts are struggling. It might feel difficult to revert to COVID, but we are still recovering from the slowdown that took us to something like 55,000 children in the system. We're sitting at 44,000 now, and we've got no less demand than we had before COVID. In fact, it's on the rise. So I think the fact that we have got improved performance on delay is something to be positive about. But I think there are a number of issues that we'll probably talk about today that we need to think about, including the experiences of children and families in the family justice system, but also how we move to the intended reforms.
What else?
Yeah, do you want to go? So just to add to that,
there have been recent improvements in terms of delays, but the system's under immense pressure. I would say, though, that performance in the family justice system is almost entirely measured in relation to timeliness. And that is a problem in itself, in that we don't have a way of measuring whether the system is effective in terms of improving children's lives or really understanding the experiences of parents and children.
I would have said something similar. I can add that, and I'm sure we'll go on to talk about it, but I published a research report a couple of weeks ago, and I'm sure I'll pick out many things I want to tell you, but in relation to this, one of the startling statistics in it was that 30% of the volume of the cases we were able to look at were returns to court. So it gives you some indication of how, if matters are not resolved or matters are ongoing and more protracted, you get a sense of what is impacting the court in terms of pressure and volume. And the other thing I'm sure we will go on to talk about are the reforms which we refer to, you're probably aware of them already, Pathfinder courts, which do create more pressure on the system at the start, but I think pay off in dividends. But we should be cautious before we prioritize them as an efficiency model. They're meant to be, as Lisa said, improving the way the court understands and addresses domestic abuse. If a byproduct of that is that they are more efficient, they do have that impact, that's wonderful. But the primary measure we should be looking at is the quality of the work in those courts.
Okay, it's just sticking on timing for the moment. A question primarily to Jacky, though please feel free, anyone else to answer it. Following the 2014 Norgrove review, over a decade ago now, a 26-week time limit was introduced for public law cases, which has never been met. The mean disposal time in the first quarter of this year was 39.6 weeks. Why is that target, 26-week target, so difficult to meet?
Well, a number of reasons. So first, just to say, I think we're about 35% of cases in public law at the minute are concluding at 26 weeks, which is a good way ahead. Look, in public law proceedings, there are many reasons for delay, notwithstanding the fact that social workers are difficult people to find and to keep. And if a social worker changes in the middle of a case, it creates delay. People try and take a lot of care around the decision to remove a child from their parents, so experts are instructed. They're another reason for delay. And in many of those cases, late in the day, family members are identified to care for those children, and the proceedings come to a slow while those assessments happen. And everybody does try to find those family members right at the start when proceedings are issued, but that often doesn't happen. There are many intentions in the system to try and change that, including the DfE reforms that are on the table now in the House of Lords, around identifying kinship carers much earlier, in fact at the point of issue. But I think we're a bit of a way from that in terms of achieving that now. But I think on top of the capacity in the system, there are some understandable reasons why people try to get this right, and that does involve delay. Yeah.
I would just add that, as Jacky says, there are many different reasons which may contribute to delay. She mentioned some. There is also obviously capacity of the court, availability of expert witnesses, etc. What we struggle with is having a really strong governance structure to be able to solve those problems at a local level, because they're not things that can be solved by pulling levers nationally on their own. They also need very strong local governance, and that is lacking in the family justice system at the moment.
We'll have some questions from Anna Dixon.
Yeah, just picking up the point really about governance. So the Public Accounts Committee concluded that the current arrangements for family justice are complex, many organisations involved but non-accountable for overall performance. So at national level, obviously, there's the Family Justice Board, doesn't seem to have met very consistently. And also, obviously, at the local level, the sort of equivalent, but with no direct sort of accountability. So I wondered if you could just elaborate a little bit about how you think this complexity in terms of governance does impact on court performance.
Well, first of all, we don't really have a strategy for the family justice system, a set of clear objectives that everybody buys into. It is a complex system involving lots of different public services. And there's no one body that holds that strategy and holds the system to account. We've also got 2 government departments who have responsibility for children who come through the family courts, and they're not working together very closely to solve some of these issues. As you say, the Family Justice Board hasn't met very regularly and hasn't got a clear strategy. Local family justice boards are not on a statutory footing, so there's no compulsion to attend them. They're not very well resourced. There are some excellent examples and there's some very poor examples. But in order for it to have a system where you had strong local governance arrangements to resolve some of these issues around delay and other aspects of challenge to the system, you would need to put them on a stronger footing.
Is that what you would be recommending?
Yeah.
And for the other witnesses, thoughts about what needs to be done to address this fragmentation in governance? Are there other solutions that you would be proposing? Jacky, do you want to go first?
Well, thank you. So I agree with all of the things Lisa said. I think, the old adage that what gets measured gets done is an important one here. And I think we, following the Public Accounts Committee, do need to sign up to a strategy. The Family Justice Board have said they will and are intending to prepare one. The board doesn't meet when ministers change. We're going to meet again in December with new ministers, but there has been a churn. But I think we have to get around the reasons for delay and target them. There are 6 or 7 key reasons. I've set out a few of them here. We have to performance manage where those delay factors are evidenced. They vary across the country. In some places, there's no social workers. In other places, it's court capacity. In other places, it's the practice in local authorities. Whatever it is, we need to target specifically. And the only mechanism we have at the moment are LFJBs, because we don't have any wiring into those local places except through that system. And if we don't formalise the governance, I can't see how we're going to be able to target performance. The alternative is to have a leader of the family justice system, and I don't like to say who that is with the president sitting behind me, but if you don't have a leader, it's hard to know how you're going to get the change that you need to get. And we're working together, but it needs to go faster, I think.
But it sounds to me that given the geographical variation, that the reasons for delay differ, that you would also be advocating strengthening the local family justice boards as a form
if it's formally possible, yes.
Okay. So in response to the Public Accounts Committee, as you say, there is a suggestion that will come forward with a plan. What should be in that plan? I don't know, Dame Jacobs, whether you have any.
Well, I mean, then I agree. But I suppose one of my opening comments were much more here to private law proceedings, but I think there is some learning there. In that within the Pathfinder courts, you have an intentional coming together, coordination, some investment, and that's what is absent in most other places. So I tend to prioritize going to Family Justice Board conference. I'm very intensely interested in this area. I've gone to meetings, local meetings. In fact, the last one I went to was at the Cafcass main building. And what you essentially, if I could describe what you see there, you have system leaders around a table, but with very loose direction most of the time, often spending their own time and energy in terms of the kind of problem solving you practically do or would be required or needed. There is quite a lot of variance in the way that Lisa describes. It feels very often people volunteering their time above and beyond. That is not a way to coordinate and problem solve through these issues. And so it is absolutely true that local family justice boards do need more input, direction, resource, all of those kinds of things in order to engineer some of these changes and improvements. And that just simply is not in place. Although family justice boards meet, and as Lisa said, some are clearly better than others, but a lot of the chairing of that board, the people who are doing the heavy lifting in terms of reform, it will be on a basis of just putting your hand up, not necessarily the strong, clear direction and program of change, in my having sat and observed in quite a few.
I don't know, Chair, I think we may have touched already on the sort of long waits, these cases where over 100 weeks. Obviously, the Family Justice Board did set some ambitious priorities for 2024-25, including reducing the number of cases open for over 100 weeks to zero. That's both private and public. I think you mentioned the 4,000 children who are waiting in cases that are open for over 100 weeks. So I suppose, is this was it the right target? And, if not, what should be the targets? And I guess given the conversation you've just had, getting the Family Justice Board's targets to actually have teeth locally. So I don't know, Jacky, you want to come back on that briefly?
Thank you. If I could come back to the strategy as well in a minute, but on the 4,000 children, it's 2,000 now,
okay,
which is secure progress. And I was just reflecting on Lisa's point that is timeliness the right measure? Until we clear enough children out of the system and the long-running cases, we can't even begin to be more ambitious. So I think sticking with those priorities that the board has are the right ones. I think it is right to say nothing over 100 weeks, and in fact go to 90, because that takes you to a better place. And we have to push harder and further, but again, it is regionally variable, and so requesting evidence and progress and improvement priorities in the places that are doing better or less better is an important addition, I think, to the target, and that's what we're intending to do, is to go hard on the places that are doing less well for whatever reason, not a judgment. On the strategy, though, I think we have to start with what are the outcomes that we expect in family justice for children and for their parents. And it is a worry that we have a system that doesn't know what happens at the end of proceedings, because we invest a whole public service architecture behind it. Nevertheless, that said, it would take even more resource to establish what those outcomes are, because for Cafcass, we finish when the court case finishes. We don't know what happens to the kids unless they come back. So it needs thought and resource, but it is, I think, important for us to consider why we don't know what happens. And as Nicole said, 30% come back, which is a huge number.
I would just add, family drug and alcohol courts, for example. I mean, having visited Birmingham recently, some of these ways of working are funded kind of originally through Department for Education, MOJ, and then it becomes the local kind of local authority cobbling together. I use that word on purpose, cobbling together of funds to carry out ways of working that really they may not meet timescales in the same way, but the sense of quality it is by all measures improved. And I feel that remains quite neglected in terms of the driving from the center. Shouldn't we be learning from these efforts, supporting them, finding ways that I believe they're quite cost effective essentially? But it was quite shocking to me to realize that in these courts, particularly in Birmingham, as I said, they had original kind of seed funding, but then were really struggling to maintain efforts beyond that time period. That's not a way to kind of strategically fund good work.
I think we'll probably come back to that. Thank you, Chairman.
Testament.
Thank you. I was going to move to early intervention, and the previous government had a consultation supporting earlier resolution of private law family arrangements. I just wondered, and that government also said it wanted to work to make pre-court parenting programs the norm. So I was going to ask you a little bit about the reforms that were underway and what pre-court parenting programs are available now.
Outside my remit, but I'll have a go. So there are a range of mediation schemes. There's obviously the government-funded mediation voucher scheme as well, which is designed to incentivise mediation. We offer all parents the Planning Together programme, which is an intended cooperative. How are you going to tell the court that you're co-parent, technically, if it's safe for that to happen? That isn't the case where domestic abuse is a factor, known or reported. We don't recommend. But I think the range of provision isn't necessarily the issue. I think it's that certainly for Cafcass, 60% of our private law applications exempt themselves from a mediating opportunity because of domestic abuse. And that of itself is difficult because you're straight into the adversarial court space. And I'm not sure there's a better answer on the table for parents who are trying to make arrangements for their children where domestic abuse is known. I think that has to be in the court space. So there is still, for me, how do you narrow the front door into court so that people can cooperatively resolve matters for their children. And I think the provision is there. It's whether or not it's taken up.
I would just add, it's worth remembering that only an estimated 1 in 10 of separating families come to the courts. The majority don't. And we know from all the evidence that parents prefer not to come to court. They try and resist coming to court. It's the step of last resort. As Jacky says, mediation rates don't seem to have increased despite the voucher scheme because it doesn't seem to be appropriate for the families that are at the court door. What we don't have evidence of, but we need to understand better, is what is available at a much earlier stage for parents. And this is where other government departments have a role to play, DWP and DFE, as well as the Ministry of Justice. So I think it's about sort of thinking about it much earlier in the process, at the point of separation, which is a long process, and people don't turn to the court until they absolutely have to.
Yeah. Do we have an idea of the non-court options? Is there a sort of...
There is no information that we can turn to that tells us what is currently available. And no, that's the case for parents too. So when you're separating, you only find out by asking friends or family, or there is no one-stop shop to tell you what is available. And that's something which the Ministry of Justice said they would try and have a look at, think about setting up some sort of website for parents. That hasn't happened yet, but no, there's nothing at all currently.
Thank you. Can we pick that up? Thank you. My last question was the Children's Wellbeing and Schools Bill provides for family group decision-making meetings, bringing together family members and professionals so that they can make a plan in response to concerns about a child's well-being. So they're meant to be a gatekeeper to care proceedings. Do you think that's effective? Is that what happens? Is this reducing? Are they likely to reduce the number of babies being made subject to care proceedings at birth?
So the evidence around family group conferencing, which is a particular model that comes from New Zealand, is very good, very strong. It does result in more children staying at home with their parents or remaining in care for a shorter period of time. I think the concerns about the measures in the bill are that they don't specify the process in sufficient detail to match the quality of family group conferences. They leave that to the discretion of local authorities. I know there are a number of amendments that have been put down to try and strengthen those provisions, and I think that would help to ensure that the quality of what is offered to families at that stage does meet that standard.
Okay.
Could I add something to that?
Yeah.
Could I add something? I think the principle is a good one because families can and should come together around children, but I think there is a risk currently that the child protection issues that are around for those children at the time that you're about to issue court proceedings might just fall off the radar, and there's a determination at the moment to divert those carers into private law away from public law. And if they come into private law now, they'll come into a system that's delayed. Very young babies can't be in that situation. And the parents nor the child are represented in the same way that they are in public law. So there are some protections that need to go around that principle if it becomes statutory.
I mean, I can't help but have to add, because I'm one of the people backing one of those amendments in terms of the Child and Wellbeing Bill. And I feel very strongly about, I understand the quality of the evidence backing that. But when you put yourself in if you are a victim of domestic abuse and you are entering into systems where perhaps you're not familiar with what those systems are, you've never had exposure to some of this interaction. Number one, we can't assume that someone would say, I am a victim of domestic abuse and I need you to understand that. In fact, that would be somewhat rare. Very often, adult victims accept that everyone around them, or have a high expectation that everyone around them understands domestic abuse, what you should safely do. And that is sadly not the case in many cases. And so they'll accept, I'm meant to go to this family group decision making. Everyone's expecting me to do that. I don't feel safe in this situation. I don't believe that I'm able to be as forthcoming about my concerns as I could. And then you feel this, it's almost a system induced risk if those things are not dealt with. So yes, it's maybe wholly appropriate for some families, but there have to be safeguards for victims of domestic abuse. There may be some people who say, no, I feel fine with this process. This is okay. But the choice has to be there. The explanation has to be there. The understanding of the safety, there has to be some safeguards so that we don't have this expectation that it's a one size fits all. And that has to be made clear in these reforms. I'm afraid it just won't work for everyone. And we have to understand that that could create more problems. And there's so-called honor-based abuse where you have wider family members. We have to just be very aware of these kinds of things before we have that high of an expectation that that family group decision-making would be appropriate in all cases. And that needs to be made clear. I think, as Lisa said, the way the legislation is currently drafted, there's a lot that's being put into, we'll sort that out in guidance. That's not appropriate for a system where we know 60% at least of the volume of concern will relate to domestic abuse. So it's core business. So we have to understand we build the system around that knowledge.
Yes, George.
Yeah, I wanted to ask a little bit more about the family group decision-making meetings. And, we've discussed what some of the merits are or could be of those. There will be some families where domestic abuse is taking place and that domestic abuse is present in the running of those meetings, and people have expressed concerns around that. Do you share some of those concerns? And what can local authorities do, for example, or anybody else to help make those meetings safe?
Yeah, I think beyond the legislation, I mean, I do think the training and the quality of training, the support for for social workers or anyone in participating in those meetings that they feel confident and able to understand domestic abuse well. Having that independent advocate for the victim, adult victim, is really important so that they have an avenue to share concerns and have someone who might stand alongside them and say, I want to help voice these concerns if needed. I think I was speaking to the minister this morning about this very thing, having some very clear water between the understanding of what is going on and at what point do you have a choice? Are you able to raise concerns? This is how often adult victims feel kind of swept into systems where they only look back and think, had I only maybe drawn a line here or there, but I didn't feel like I could. So it is just making sure that we have those safeguards and parameters and safety issues flagged and kind of baked in to the process. Thank you for asking.
Thank you. Anything else, Josh?
Could I just
Jacky
add one last thing? I think local authorities are highly skilled at dealing with children in child protection in the child protection system. The family group decision making conference is an intention to try and engage members of the wider network for children to avoid care. That's explicitly what it is, and it's a good principle as long as all these arrangements are clear in guidance. So if working together is rewritten, which is going to be, that's the statutory set of rules that a local authority has to follow, it should be very clear about what happens to the victim and the adult and the child victim in that conference, where the perpetrator is or isn't in those arrangements. And I think they do that now in child protection conferences. My issue is that they're doing that very late. If you're doing it at the point you're writing a letter to parents to say, we're really worried, the risk hasn't gone away, we're going to remove your kids, everybody's up on the ceiling at that point, and it's quite hard to manage. It needs to be much earlier to put all that protection in. And I think I've been on record said that before. So for me, that's the key.
May I, Chair, just come in with a very small follow-up on this? So I was talking to the grandfather of Star Hobson, and people will know the tragic case in Bradford where Charles was murdered by a cohabiting partner of the mother. So I just really wanted, and obviously he wasn't involved in the discussions about child protection, that these early conversations will involve grandparents, and the intention of the as you understand it, the family group decision making meetings and the model that's come from abroad would actively engage grandparents and also seek to go beyond, in this case, obviously the person who was perpetrating the domestic abuse, to try and get some independent adults who are also knowing that child involved in those decision making. Is that the model, and will grandparents be actively involved?
When it's done well, that's exactly right. Not just grandparents, but aunts and uncles, and a very thorough job is done to look at the whole extended family network. But I think this is all about nuance, as the answer to the questions suggest, and we don't want a system that's sort of forgotten about extended families for a long period of time to then lurch towards insisting that all children look to extended families. The point is that it's going to work in some cases, not in others.
Thank you.
Can I just pick up a point that you made, Jacky, that I think is really important? You said that you were concerned that babies are essentially going to get sort of lost in this system, or that there's a risk around that.
Yeah.
Could you expand a bit on that?
And it's a worry, not a known issue. But I've run a local authority before, and putting a family group conference together is difficult. And when there are very young babies, and there may be 3 or 4 of those family group decision-making moments, you may be 3 months across a period of 3 months, and for very little children who need primary attachment, who are already with a carer, that just needs to be thought through, including if the decision of that family group decision-making conference is that Granny will be the carer, then she is going to have to be in a process to become that special guardian. And if it's not in public law, which it's not intended to be in the reforms, and it's in private law, it needs to be fast-tracked so that those children have permanence quickly, rather than get caught in a process that doesn't have any structure around it. So there needs to be a child protection plan and a fast track into family court done for those. I don't know whether you say it's for under ones or under fives, but that's what I'd be worried about.
And does that fast track exist at all at the moment?
No.
Can I just also add that a lot of those families have already had a child taken in care. The level of recurrence is really high. So for many of those families, they will be known to the local authority. They will have had a long practice. So I take your point about the need for avoiding delay when you have young babies and needing to move quickly. But it is often the case that the family at the centre of the child protection concern and the wider family should be well known to local authority for a long time before that point.
One of the things that I remember seeing when I was working, adjacent to this area, and I don't pretend to more experience in it than I have, but was children who parents had 1, 2, 3, 4, 5, 6 children taken away previously, and there was still an assumption that that child was going to remain with the family and see how it went, essentially, albeit with court supervision and social work supervision. I know, Lisa, you've said that you've got concerns about the evidence base around families. Do we have evidence on that, and do you have views on it?
We've published research about the extent of recurrence. I should say it's really high in public law care cases. We've recently published research which shows that if a mother has had a child taken into care and then goes on to become pregnant, 1 in 2 go back into care proceedings. So that cycle of repeat care proceedings is making up a lot of cases in our family courts. There's also some very good evidence about how to support families in those situations and how to break the cycle of recurrence. So I wouldn't say that. I think to your question, there is good evidence that you can help a family to care for a child when they've previously had children taken into care.
Mm-hmm.
But what we have at the moment is a system that is focused on removal of the child rather than support for the family that is left behind. And that's what we need to shift. And it's one of the things I would advocate for a KPI for the system. I think we should start measuring recurrence as a KPI for the family justice system.
We need to move on. Pam Cox.
Thank you. That was going to be the last of my 3 questions, but since you've led us into that, and thank you, Sarah, for that too. No, it's you're quite right. Breaking the cycle of recurrent care proceedings is vital. It falls between every crack in this system. It's not a measurable KPI, but as we know, and I personally was involved in this in my previous career as an academic in designing measures that could capture the effectiveness of efforts to break recurrence. So we know about the Pause project that was rolled out by the DFE to many local authorities. We know about many other local authorities and charities that had projects locally. We know that there's a community of practice that's developed to support those groups. We know that for every £1 invested in working with a family to prevent recurrence, you're saving money for the system. So what's happening with that now? Where are we at? Are those surviving services safe? Are they at risk? What do we need to do next?
They are at risk. There are small-scale services that are reliant on short-term funding, and they're doing great work with small numbers of families. And the community of practice gives them a chance to share their knowledge and swap their experiences. But what we don't have is an infrastructure in the country which supports these services. So it is a concern, and I absolutely feel that this is an issue, as you say, that falls between the cracks of services, but that at every stage of the process, services have a role to play. So, if a court has agreed to a care order, the judge should be asking about the support that's available to the family next. If the local authority should be following up with that family, there should be every effort to ensure that there isn't this repeat cycle. But at the moment, because we're not measuring it, it's not something that we're holding the system to account of.
I remember over a decade ago when the hope was when pre-proceedings came in and that every family had a right to pre-proceedings, that it would follow that every family would have a right to post-proceedings of some kind, which became known as measures to avoid recurrence. So that we're no further along, 10 years on, in developing a statutory right for parents to post proceedings.
And the data shows that we're at the same level of recurrence that we were 5 years ago. So
and a third of the cases are recurrent cases. So this is something really MOJ and DfE need to look at again. I would say. I don't know if you're nodding there.
Absolutely. I mean, depending on the circumstances, it mirrors very much what you see for wider domestic abuse services, which some might be wholly appropriate in these instances as well. But you have often, national funds which will start something. And then there'll be kind of an expectation at the local level that somehow, despite it not being apparent that it's true, that somehow MOJ or DfE will continue to fund. There's not a real strategic planning at the local level, or kind of a cascading of what is the responsibility, how will this stay and continue? And it becomes a muddling of trusts and foundations, a bit of local authority funding, this kind of effort to survive for these services. And the irony is they're, as Lisa said, very, very impactful and effective. And we need a much more strategic way of funding, I would say, those services. But it's true of the whole of domestic abuse services, full stop. They're not a statutory duty. And therefore, the minute there is constraint at the local level, there is quite a lot of salami slicing, frankly. And what it means is, as much as they make progress, then they'll kind of take one step forward, 2 steps back, because they are having trouble retaining staff, maintaining the service provision. And many victims of domestic abuse and others who are subject to care proceedings will say, I had a huge amount of attention, and then it all has dried up.
I think with the Chair's permission, we might write and follow up on that, just to check in on where we're at nationally on that. I had 2 other brief questions. One around Pathfinder courts. Are they making a difference to families experiencing domestic abuse and the children involved in those families, from your perspective? Are they? And the second is around FDAC, but let's go with Pathfinders first.
Want to start or not?
I know we talk about this subject quite a lot. I'm very enthusiastic about Pathfinder courts. So now we're switching over to kind of private law proceedings, where we know the vast majority. The report I published recently, or the research I published, shows it's the everyday business of private law proceedings. People who cases where there's upwards of 90% aspects of domestic abuse. And what Pathfinder has done is it's created a much more realistic methodology to understand the context of the family early, the context of each child early. And there is a domestic abuse assessment that's done, which I think is really critically important. That puts a lot of pressure on Cafcass and others in terms of that kind of front-loading work. But it is, in my view, the way you would design a system that is meant to have knowledge in front of decision makers as early as possible, so that things don't become so protracted, prolonged, and you don't have, as what we've seen in many courts, some concern about domestic abuse raised, counter allegations raised, and then we, because we haven't invested in that kind of knowledge at the start, focus on the child and the child's voice at the start, things become much more confused. And so I do believe that it's a better way of doing things. I have concern that we don't think of it as the kind of end all be all. It needs to improve as it goes. We've got Pathfinder in a handful of sites kind of fully implemented and a planned rollout. But again, this is the kind of thing that is so important that we need to make sure, are we resourcing it properly? Are we learning as we go? I would like to apply the same methodology that researchers used for the report I just did, which were not, by the way, Pathfinder sites. They were two courts in England, one in Wales. But we now understand a bit more about that methodology, how you can go into court without it being disruptive. I think that should be applied to Pathfinder sites so we can learn as quickly as possible. But yes, I think there are lots of other issues. They don't involve what we see a lot in terms of financial remedies. There's a real siloed approach between these proceedings, financial remedies. So it's not, again, it doesn't cover everything. But I do think it is a very important step forward. And I think the president, should be commended for leading that and also the transparency he's given us and allowed my office to have in the research that I've published. So yes, steps forward, but not, I always end with this. I have huge concern for anyone who's in family court in terms of what we know of domestic abuse being minimized, sometimes overlooked, people feeling children not heard. You can see that all in the report. So it's an urgent issue, the kind of planned rollout and scale and resource needed for Pathfinder.
And on FDAC, if I may, Family Drug and Alcohol Court, Problem Solving Court, has very, to my mind, robust data showing its effectiveness. Where are we at with the plans to roll out FDAC more generally?
It's another example of an initiative that is dependent on small pots of funding year to year and the energy and enthusiasm of a small group of people who are prepared to get it off the ground. The number of cases is still very small that FDAC is dealing with, but the evidence base is really very powerful and very strong, both in terms of the chances of a child returning home, the savings to the court in terms of fewer hearings. I think it's a very important example of the role of the court in ensuring that families have an opportunity to change at every stage, including a court stage, and using the power of the judge to ensure that the family has a chance to really participate in that process fully. So it's modelling a way of doing justice, which I think is very popular with families and very effective in terms of its impact. And yet, at the moment, it's just reliant on, as I say, small pots of funding and the enthusiasm of a few people.
Can I just come in on both? After I agree with everything, but I think it's time to nail our colours. Really, got a system that is proving to improve outcomes for parents and children. The answer is money, and there's not enough to go around. So, but if we're going to have FDAC, we need it everywhere, not just in some places with people cobbling together money. And on Pathfinder, it's the same, really. If you're going to have specialist domestic abuse provision supporting the courts, then it needs to be baked into the budget, into the resource that's coming down the line. But also, it's not the model of the court that will sort the experience of children and victims out. It's the quality of the risk assessment that goes on to present advice to the court. And Cafcass has a role to play in strengthening that, doing more and better. And that's what we want to do. But it's only possible to assess children if you see them. And that's why we need the change to Pathfinder, because we only see 30% of kids now in the current system because we're not able to see more.
Thank you very much.
Very much. Lizzie Farns.
Thank you, Chair. I mentioned I was a former Crown prosecutor, so it probably won't surprise you that I really want to delve into domestic abuse situations and the interplay with the family courts of those situations. So the first thing for Dame Nicole, if I may ask you about coercive control, I am aware of concerns that perpetrators of domestic abuse often use the family court as a vehicle or weaponise that court process as a means of coercive control post separation when it's a domestic abuse situation. So can you explain how the courts are used by perpetrators in that respect?
In a variety of ways. Very commonly, the most kind of common tactic, and I do believe that having, again, in the last few weeks, been to many conferences where there's a lot of barristers, lawyers who work in family court, they use the term tactics, and they're often employed by representatives of the perpetrator to say, when domestic abuse is raised or explored, there's very often a counter allegation made of often using some kind of term, so-called alienation or parental alienation. Essentially saying, well, this is only being raised because you don't want me to see the children. And where Pathfinder helps with that, I believe, as Jacky said, if you can talk to the children, you understand whether their reluctance, refusal, resistance is based in the fact that they are, in fact, a victim themselves. That what is their context, and understanding that goes a long way. But what's been happening now for many years, and it's very well documented in a number of reports, is just this dynamic of kind of using the court in this counter allegation. I mean, very commonly, I speak to victims all the time who will say they've been drugged back to court over and over. And so it looms large. It's not uncommon for me to hear someone say, it's taken 10 years of my life, always kind of looming, thinking, when will we be back in court again, to change, application to vary arrangements, those kinds of things. All of that just creates enormous stress for the child, for the adult victim. That's the kind of the most common starting point. But one of the things, there are lots of ways we can do this better. One of the byproducts, for example, of Pathfinder is in doing that assessment, adult victims have an interaction with local domestic abuse service in their area, as Jacky mentioned. And then they usually are then much more aware of the kind of support that they could have. There's so much more needed. There's also quite a common dynamic of people representing themselves. Cuts to legal aid mean that litigants are coming to the court representing themselves, finding it much, much harder, obviously, to navigate some of these tactics used, and just the court itself. So victims very much get lost and sadly further abused by systems which are really not understanding or offering those routes to support and help early enough.
I mean, that's really worrying to hear, but not surprising from my experience in my past life in the Crown Court. It's been 5 years since the harm panel report, and you've mentioned the Pathfinder courts. I'm just wondering what other progress has the Family Court made since the harm panel report came out to change the way it approaches domestic abuse within the family court setting?
Some of the things I'm most enthusiastic about are, I feel like I've said to you most of my thoughts on Pathfinder. I'm very enthusiastic about my interactions with Cafcass in Wales, Cafcymru and Cafcass in England. They both, in both instances, have revised their domestic abuse best practice guidance. Cafcass has best practice leads who I've met and spent quite a few sessions with. These are all things that I feel are really important and impactful. I've seen quite a lot of family justice boards, local family justice boards host conferences on domestic abuse, maybe for the first time ever, which is quite surprising, but sometimes that is the case. And, bringing together all of the players, local solicitors, a whole range of people, sometimes interacting with domestic abuse services in their area in those conferences for the very first time. There's some really interesting work going on in relation to taking some of those harm panel recommendations and localizing what that could look like. So there are some family justice boards who've linked with trusts and foundations and have really tried to kind of regardless of what's happening with Pathfinder, what MOJ or anyone else is doing, has really tried to localize and implement in their own way improvements. So I feel like we've, in a way, I know victims would say this has taken too long and it's been too frustrating. And I certainly speak to victims who feel their lives have been, destroyed is probably not an exaggeration for some of the people I've spoken to. But despite all of that, it's hard, it's difficult for me to answer the question in a very black and white way, because I also am very aware of these changes, which I think are showing effort, acknowledgement, a need to change, a need to move forward and improve. And that's exactly what we need. So I can see both sides of it. We're not there yet by any stretch. Have a look at my research, which is fairly recent indication of a snapshot. So we're not there yet, but we've made some real strides. And certainly, we just had the government last week announcing that it intends to change the presumption of parental involvement. In other words, focusing rightly on the welfare of the child, the legislation in the Children's Act, which prioritizes the safety and welfare of the child.
I think we'll come to that in a little bit more detail, hopefully shortly. It's good to hear the progress that's being made. Your recent your family court review and reporting mechanism pilot, I think, found that there were structural barriers. I've heard you talk about some of the barriers, resources, for example, this afternoon, but that found that there were structural barriers. The harm panel found that there were structural barriers. Would you say that those sorts of structural barriers still remain despite the work that's going on to improve things generally? And if so, do you think that the rollout of Pathfinder courts will address that adequately?
I feel that some of those structural barriers are very persistent in terms of, when you think about systemic change and how long often that takes. It shouldn't surprise us. I always do remind everyone anytime I speak, we had our first refuges 50 years ago. None of our systems were built with a very good understanding of domestic abuse, or certainly not a shared one. And so on one hand, we shouldn't be surprised when we see these structural changes that are needed. Yes, we're making some headway, and we have to keep at it. I believe in Pathfinder to the extent that I think the best systems change, or when, some people say they want to train train it into people. I think people really change in their day-to-day life. I certainly have, is when I'm working within a system that I feel is doing a good job, that is really meeting its aims. And I think Pathfinder allows people to feel that they are doing a better job. And that does create change. It's different than sitting in a training room and saying you ought to do this, and then you enter a system that doesn't quite work that way. But one of the greatest concerns I had about this recent research is this persistent notion that domestic abuse is quote unquote in the past, and that it's historical. You hear this a lot. Some of the quotes in that research, and for it's not unusual for me to talk to older survivors who will recall what they feel with great emotion, having been raised in a family where there's domestic abuse, and it's obviously impacted them their entire life, and they feel so strongly. So this notion that somehow if the physical violence or the kind of absence of someone kind of in your life for a relatively short period of time means that in court it's considered historical, I think that is still a huge problem for children. And that's why, as Jacky said, we must tune in and have the ability to get to know the child, understand the impacts, understand their view, get beyond some of these labels and really understand what any kind of reluctance could be about, And really, we owe it to them because these are life-changing decisions that courts are making.
Thank you. If we can move on to still on the topic of relationships, really that you've just moved on to, and talk about alienation of a child, and perhaps I can bring Jacky in as well on this one, please. Where there's allegations that one parent has alienated a child from the other parent, in both of your experiences, is the court able to adequately assess those allegations fully and respond to that behaviour appropriately at the moment? And if not, how would you like things to be improved in that respect?
Shall I go? I feel like you all are so much more expert than me.
Okay, just in terms of alienating behaviours. So our policy and our position on alienating behaviours is that when it is alleged in a set of proceedings, that our first question about why a child might be refusing to see another parent is there domestic abuse or another form of harm? Sexual abuse or physical abuse. And that's the starting point for us for that child. And if our assessment is that those other forms of harm aren't present, then we do go to why would the child not want to spend time? And there are situations where parents are in conflict and one parent says horrible things about another and influences the child. That happens. There's many, many cases. But what we've done to strengthen the position that it's not used in the proceedings inappropriately is to start with domestic abuse. So family court advisors in the policy are required to say, why doesn't this child want to see this other parent? And we choose to resolve conflicts and arrangements for children in this country with their parents through the family court. Whether that's the right situation or not, other countries do other things, but we do it in the family court. It's an adversarial space. And the court is stuck between having to make a decision to do a fact find in those cases, which will create delay and slow the whole system down, or not. And those are difficult decisions to make. And I think we just have to be thoughtful about what we're doing to help social workers recommend fact finds or not. When should you, when shouldn't you? And also for the court then to make its decision about whether that's a reasonable piece of advice or not. But in the cases that require that allegation to be investigated, then there should be a fact find. And where there is alienation and domestic abuse in the same conversation in those proceedings, that the only way to investigate that is for the social worker to put their advice to the court and the court to have a fact find. So,
and I don't envy you and your colleagues having that task. It's an incredibly complex situation, particularly with what we've discussed about the domestic abuse relationship setting as well. And I'm also conscious that Dame Nicole mentioned the pressure that Cafcass are under generally and resource-wise as well. So I am conscious of those things when I ask this next question, which is in relation to the harm panel that did criticise Cafcass in relation to its approach involving domestic abuse. And so I'm just wondering what your response to that was. Have adaptations been made? Has there been progress on that following that panel report?
Yep. So I arrived shortly after the panel reported, and it was a tricky time. I think the criticisms we've taken in and thought about, and we have made some changes. I think our sense of ourselves and our practice is that things have improved. Domestic abuse is a national priority for us. It has been for 4 years. We've got a domestic abuse improvement programme. We introduced a new policy last year and then again early this year, where we've attempted to set out really clearly what we expect family court advisors to do, and it's a tricky balance because the advisors are appointed by the court. They're employed by Cafcass, but they're independently appointed by the court to advise the court. So we set out a set of requirements in policy which they are now expected to follow, and I can't quite reveal the result because we've just had an Ofsted inspection on the same and the report's not published yet, but there is evidence, I think, that our policy is improving practice, particularly reporting very explicitly to the court what victims are telling us, whether it's before the first hearing or in the work after first hearing, and that the position we've taken, which is if you have a known criminal history, have served a prison sentence, there is a police report, or you're being investigated for a violent or sexual crime, we will assume that you are an adult of significant risk to a child, and we will advise the court how we've assessed that and how we've assessed your suitability to have contact with your children. And that is a position that we set out very clearly, and I think our advisors have found helpful. We're not taking away the authority of the court to make the decision, but we are saying very clearly, this is this person's history, this is what the police have said, regardless of whether there's a conviction or not. So we've tried to be more explicit about violence and harm in family life. And we have an expert panel of people with lived experience who advise us now, including 2 secondees from Safe Lives who work with us to improve practice. So I think we're travelling in the right direction. I wouldn't want anyone listening to think I'm saying we've sorted it, because we still haven't. But it is tricky business.
Yeah.
Thank you.
I'm going to, it's frustrating because this is all valuable evidence, but we're going to have to go considerably quicker if we're going to cover all of the topics which we have to deal with. So I don't want to constrain anybody, but can we just all bear in mind the time limits? And we have votes. Josh, did you want to come in on this?
I don't think I had any more questions.
That's fine.
No, I'm good. Thank you on that.
Then we go on to Matt.
Thank you, Chair. Thank you. Dame Jacobs, you briefly mentioned the presumption of parental involvement. So yeah, the government, after lots of campaigning from colleagues across the House and both houses actually, have announced last week that it wants to repeal the statutory presumption of parental involvement. Just wondered for all the panel actually what your sort of thoughts are about that, and is it going far enough? Is it not far enough? You know, that general comments.
I welcomed that announcement, not because I think alone it would remedy all of the issues that we've raised today, but I think it sends a very strong message and signal that the safety of children should be paramount. And I do believe that most actors in the criminal or in the family justice space do fully understand that. But it is very true that we do have some of this dysfunction still, or some of the kind of issues that are still arising. And it's an important signal to send. It would not be as impactful if we don't start to address some of the other issues we've talked today about, the kind of cultural changes needed. We haven't talked very much today about legal representation and the impacts of legal aid cuts, the impacts of, there's a QLR scheme, a qualified legal representative scheme, when people are representing themselves, which doesn't work incredibly well. There's a lot of ways that the court needs that focus, resource improvement. I believe that in the Ministry of Justice, so much is overshadowed by our criminal justice system and what we hear about in the news or the media. We need ministers within MOJ to feel how equally important these issues are. These are, again, decisions made within family court have lifelong impacts. And that kind of attention and bandwidth within government really needs to reflect that. And I don't believe it currently does. So you see a lot of the wheels in the system are not getting the kind of attention that they need. So it doesn't all hinge on kind of one decision as such. It's about many, many different things, I believe. And it depends. I mean, everywhere I go, every judge I ever speak to, or at family justice conferences or anywhere else, I ask this question: how much does the presumption, how much is it overriding, is in the front of your mind? It's very difficult. It's not written down as such. It's very hard to evidence that. But I do believe it shows a clear direction given that will be impactful.
Yeah. I completely agree. I'll be very quick. I think the evidence is really clear about what matters to children. And so we've published evidence looking at what kind of contact with family matters to children in terms of their well-being. And, you cannot have a one-size-fits-all approach. You have to have a very child-centred approach. The paramountcy principle is just that, and we should stick to that. So I agree with everything Nicole said.
I think I'd just add, I think if we asked 100 people on the street, should children be involved with their mums and dads if it's safe for them to be so, I think most people say yes. But this legal overlay that we had of presumption made it more complicated. So I think it is a welcome change to say right back to safety and welfare. Is it right or not? So yes.
One very quick follow-up, if I may. One of the biggest campaigners, Claire Frossell, as you'll know, unfortunately, sadly lost her 2 children to her ex-partner. With this change in the law, presuming you would agree that potentially is going to save children's lives then, right? Is that what you'd agree with?
I wouldn't sign up to that statement. I think why Cafcass welcomed it is because the path is clear to assess safety and welfare and the best interest of children without the proof of without having something that says prove otherwise, because the presumption is that the child will have both parents. I think what will save children's lives is people stop being abusive to their children. But the quality of the social work assessment, which isn't a science, it's a professional judgment in the end. But if that stands alone for the court, rather than a lot of legal professionals saying, well, you haven't proved, have you, that this is not good for the child, I think that will be a clearer conversation between the social worker and the judge.
I think she's an incredible campaigner, and what she's been through, and the loss of Paul and Jack. I mean, I think it's incredible what she's been able to achieve, and I believe, it is about the whole systemic approach, the cultural change, all of those things together. I think that's essentially what she's meaning when she uses those words, and she should be very, very proud of the kind of 11 years of campaigning that she has put into, very much spearheading that change. So,
thank you.
Josh, you're coming.
Yeah, it was about domestic abuse in the family justice system, but moving slightly away from the topic that we've just explored. So in the family court, it's for some time a finding of domestic abuse has been able to be made. And I've been campaigning for some time for something equivalent or with an equivalent impact to exist in the criminal justice system. And in the sentencing bill, we've got that, which is fantastic. And we'll be voting on it again tomorrow. And I wonder whether there are any pitfalls or at least learnings from the way in which the finding of domestic abuse happens in the family court that we need to apply to the criminal system.
I really welcome that work, and it will be pivotal, especially with the sentencing reforms afoot and so much more community-based the sentencing, but also recall measures and early release measures, to be able to have a system that can identify what are domestic abuse related crimes, which it currently doesn't. So I'm really pleased, and thank you for that. I suppose one of the things that I think applies across all matters within the justice system is the the inability often for us to understand if, as Jacky mentioned earlier, if something is quote unquote proven versus if the system is having to assess not based on any past history or known history, or a history where the victim themselves hasn't asserted domestic abuse, is indeed a victim but hasn't used those words and hasn't been able, and now the system has to kind of understand. I think that remains really difficult. It probably will on the criminal side too. There could be people who are convicted of something altogether different. They happen to be a perpetrator of domestic abuse. People don't understand that or know those risks. And I think one very common impact from the criminal justice system into the family court is when there's been a no further action. So very often, 1 in 6 victims won't ever have, 5 out of 6 won't ever have called the police. Many who do don't receive a charge or conviction based on that call. A lot of no further action. That you bring that into the family court realm, and that's perceived as no evidence. Well, then there was no evidence here. That really works against victims in those circumstances. We have a high expectation that somehow there will be quote unquote evidence, and that's just not the case, which is why we depend so much on these assessments within the Pathfinder court model, the domestic abuse assessments, the work of Cafcass. We have to become more confident that we can make these assessments and understand when we don't have the luxury of that evidence.
And I think, I think false positives or negatives, whichever way around it is, from sort of definitive findings are a risk. So they inform, for sure. But if there's a finding of nothing, that doesn't mean it's safe or secure. So you have to go on to carry on assessing, basically. You don't just take that as a line.
Thank you. Sarah,
Jacky, in terms of the digitization of the family courts and the court system, the private family law programme was only rolled out in March 2025. In terms of both public and private family law proceedings, how is the court's computer system functioning?
So I'm slightly outside of my sphere of expertise, so I can only talk about the portals from our experience. And we've got the public law portal up and running, and that had a difficult birth, but is there or thereabouts. Although when the system does go down, we stop receiving applications. So digitization isn't an answer always.
Those when the system comes, A, how often does the system go down? And B, when it goes down, is when it comes back up, do you have them still there, or are they just lost?
No, they're not lost. So I don't know how often it happens. I don't always get told, but it recently happened for 2 days, and the applications don't come to us. So when the system wakes up again, we get a rush of applications, which in public law is manageable mostly because the volumes are a bit lower. We don't have a private law portal yet. It's in test. And there are some concerns, I think, that people have about whether that's ready to be implemented, because I think the plan is for March next year, and we are expressing our needs and concerns about that. But there's nothing, it's testing in 4 courts, I think, at the moment with variable results.
I just wanted to add that the report the research report that I just published has a recommendation where the legal academics have very kindly set out very clearly the data points that need improving. Because, of course, when they've gone through 300 some cases observed in court, the methodology they used, they learned quite a lot about, and I'm sure Nuffield has this too, they learned quite a lot about what isn't there that should be there. And I would say, please use that as a blueprint of what needs to be included in the reform and data sets.
Can I raise a concern about that there isn't a join up at the moment between this collection of a lot of useful data and a strategy for how this is going to be used to help the system understand its performance? So it's difficult to see how this new modernisation programme results in better KPIs for those working in the system, or indeed for the public to be able to see what's happening.
This may not be within your sort of sphere of knowledge, but do you know if there was a plan for how the data outputs would be used?
If there was one, it's never been shared with us. I suspect there was never one.
Thank you. Then can I just come in very briefly about the single unique identifier for children? That is contained within the Children's Wellbeing in Schools Bill. How do you expect that this will impact the family justice system, if at all?
It could be really helpful in terms of being able to link data. I mean, what we don't want to do is ask professionals in the system to collect and record more data. They're already under huge pressure. So having a single unique identifier would enable data to be linked with the appropriate permissions, obviously. It is some way off, though, in terms of how long it will take for it to be implemented. We haven't even got it through Parliament yet. So it's for the future, but it does promise to make things easier in the future.
I think for Cafcass, if we're to be involved and we've asked to be included in that scenario developing, then that would be good. But I think for us, the benefits are being able to see the checks that are run by the police and local authorities more quickly than we can, because at the moment we ask 152 local authorities and however many police forces for their information, and it takes a variety of days off the case right at the start. So for us, if we will be able to access that with the appropriate safeguards, that would be really good for families. I think we're a long way away from that.
Finally, for this panel,
yes,
Anna, did you have a question?
Conscious of keeping the president waiting, so I'm going to make sure it's punchy. So you'll be pleased to know that the Public Accounts Committee has asked specifically that we get a joined up data and evidence strategy within 6 months, with all the various parties working together on that. Given everything you've said, all the reports over more than a decade saying what are the gaps in data, I guess other than a more comprehensive set of demographics, which will take as sort of a given basic need, what would be your top pitch, one thing from each of you, as to what either KPI or bit of data you think is the most important when it comes to, let's put the emphasis on outcomes, because you've all talked about the need to move away from timeliness to outcomes. So can you please pitch for what you'd like to see in the evidence and data strategy?
In terms of outcomes, we need to move towards a measure of children's well-being, which we don't have currently in the system. As a proxy measure in the interim, I would like to see recurrence measured in public law cases. And I would also add, we need to look at inequalities, because we don't currently explore racial inequalities, for example.
Yeah. Hence, I was sort of saying basic demographics. So that's given. Thank you.
I would agree with that. I do think some of these things interrelate, but right now we don't have an ability to know how often domestic abuse is raised as a harm. We just know a harm is been raised as per the system, which is why we've had to go through the methodology we have in order to produce that recent research report. So I do think it is about understanding that, but also the outcome and decision, so that we could start to understand when certain things are raised, what are the actual outcomes and decisions made. We don't have that ability to do that easily at all.
Thank you. And Jacky?
I would like us to measure whether the extent to which children feel their wishes and feelings are being taken into account.
Thank you.
Thank you very much. So to this panel, thank you so much for attending. If you wish to stay for second part of Proceedings, you're very welcome to sit at the back. Votes coming slightly later, so I won't break now. If we don't mind changing over the panels in the full glare.